possession of a controlled substance. He is present by Zoom from low risk. Mr. Ellis, his attorney, is present. Mr. Zach Gilmore is present. Of course, probation officer Marcel is present. All right, Mr. Gilmore, what do we got on this one today? I don't see any plea papers, so it must be an announcement or something.
Your Honor, the announcement is that we're asking for a continuance. We're still, the discovery needs to be picked up, Your Honor. We're trying to get the discovery to the defense.
Okay, Mr. Ellis.
Judge, that's exactly right. Our client has accepted a offer of probation from the state. However, his case was just recently indicted. So as soon as the state can provide the discovery to us, we'll go over the discovery with our client, have him sign the plea papers, and then hopefully we can get him on probation and out of jail as quick as possible.
All right, so I do have an indictment in the file. The amount of bail on the indictment's $100,000 surety bond. It's a third-degree felony. Possession of controlled substance, third-degree felony, alleging possession of meth. In the amount of 1 gram or more, but less than 4 grams, including adults and undiluted. So it's third-degree felony as alleged in the indictment. And state and defense, having agreed more time is needed to provide all the discovery, of course, including the lab report. To Mr. Ellis, I've been handed something that didn't apply to what I'm doing now. Wasn't handed, it's stuck on the bench. This plea deadline now, counsel, to get around to taking care of this one is set for Tuesday, August the 25th at 2:30. So it sounds like from what Mr. Ellis said, it's going to be a plea as soon as he goes through all the discovery with his client. It's set for a plea Tuesday, August the 25th at 2:30. Is that acceptable, Mr. Gilmore? You got that?
Yes, Your Honor.
I'm sorry, Mr. Taylor.
No, go.
Yes, sir. That's acceptable with us. Just as soon as we get the discovery, we'll go over it with our client.
My court reporter, my court coordinator has given me a date. The date she gives me is Tuesday, August the 25th at 2:30. That date, what that date represents is the date by which the state is to have all the discovery, offense investigative reports, DPS lab analysis report, all the discovery to Mr. Ellis by on or before Tuesday, August the 25th at 2:30. That's the deadline for all the discovery to be turned over to defense counsel.
Yes, Your Honor.
With me on that, Mr. Gilmore?
Yes, I am, Your Honor.
All right, is that it, Mr. Ellis?
Yes, sir. Thank you.
So basically today, we're just setting the deadline by which you'll get all the discovery. I'm sure Mr. Gilmore to have it to you on before Tuesday, August 25th at 2:30. So apparently at this time, we are not setting it for a plea. Is that everyone's understanding?
We could do the plea that day.
Okay, we're going to do a plea that day, you know. So so now, okay, what I've got and apparently what I'll be getting is the Tuesday, August the 25th at 2:30 is the date set for the plea. And that's the deadline for the state to have all the discovery to Mr. Ellis. Suppose that's where we are. Do y'all all understand that?
Yes, Your Honor.
Yes, sir.
All right, defendants continued in custody. We'll be back on Zoom on Tuesday, August the 25th at 2:30. Mr. Ellis will have all his discovery and we'll take the plea then if y'all have a plea agreement. Defendants continued in custody. We're in recess.
Thank you, Judge.
All right, Mr. Ellis.
Mr. Spencer,
Yes, ma'am.
what deputy, is Kamen in there with you? Sergeant
Yes,
Kamen?
ma'am.
Hey, I've got Brian Morse next, but his attorney's not due to be on until 10:30, so we'll be back in just a little bit.
Okay,
All right, thanks.
thank you.
Hey, Cayman?
Who's the defense attorney? Cause number 2410624-16, which is State of Texas versus Brian Morris, Morse. This will be on the state's motion to adjudicate guilt, filed June the 8th, 2020. Brian Morris is before the court by Zoom. His attorney, Mr. Fletcher, is present before the court by Zoom. State's counsel, Mr. Gilmore, is present before the court by Zoom. The court's probation officer is present by Zoom. This being on the state's motion to adjudicate guilt, Mr. Fletcher, do you wish to waive the reading and formal presentation of the state's motion to adjudicate guilt?
Yes, Judge, we would waive the reading of the motion.
All right, the court is
We're
taking.
entering a plea of true to paragraphs 3, 5, and 6.
All right, I'm having a little trouble hearing that. I'm sorry.
Can you hear me better now? I'm trying to get closer to my mic.
Yes, sir, I can. Thank you.
Okay.
Did you say something about paragraph 3?
We're pleading true to 3, 5, and 6.
All right, let me get that down just a minute. 5 and 6. All right, Mr. Morris, I need to get you sworn in. Could you raise your right hand for me? Do you solemnly swear the testimony you'll give before the court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, Mr. Morris, the court does take judicial notice of the entire contents of the file and all the prior proceedings. The court has in this case the state's motion to adjudicate Mr. Morris, the state's motion to adjudicate your guilt. Have you gone over that motion with your attorney, Mr. Fletcher, so you understand all the allegations and all the paragraphs which allege violations of your deferred adjudicated probation?
Yes, I have.
All right, and you understand, Mr. Fletcher just advised the court that, of course, this state's motion to adjudicate, in terms of the allegations filed against you for violations of your deferred adjudicated probation, apparently it is agreed between Mr. Fletcher, for your attorney, Mr. Gilmore, I'm sorry, Mr. Tate, the state's attorney, that you are going to be entering pleas of true to the allegations in paragraph 3, 5, and 6. Is that your understanding?
That's correct.
Have you gone over the allegations in paragraphs 3, 5, and 6 closely with Mr. Fletcher,
Yes.
your attorney, so you understand those allegations?
Yes, I have.
And you understand that if you do stipulate and enter pleas of true to those allegations in paragraphs 3, 5, and 6, which allege violations of your deferred adjudicated probation, if the court finds those pleas of true or entered freely, intelligently, knowingly, and voluntarily, the court would find the allegations in paragraphs 3, 5, 6 to be true, then I would grant the state's motion to adjudicate, go back and find you guilty of the offense of possession of a controlled substance, a state jail felony as alleged in the indictment, and then the court could sentence you up to a maximum of 2 years in a state jail facility and a fine of up to $10,000. Do you understand all that?
Yes, sir, I do.
All right, now, Mr. Morris, there's going to be a document going up on the screen. It's the written plea admonishments and stipulations of evidence. Down at the bottom, Mr. Fletcher has signed it as your attorney. There's a signature on the line above where it says defendant. Is that signed Brian Morris, your signature?
Yes, it is, Your Honor.
I'm going to need to swear you to this document, Mr. Morris. If you just raise your right hand, do you solemnly swear and affirm that all the facts and information contained in the written plea admonishments and stipulations of evidence, that you understand those allegations, you understand the document, and you're signing and swearing to the document freely, intelligently, knowingly, and voluntarily, so help you God?
I do.
All right, now you having signed and sworn to the written plea admonishments and stipulations of evidence, if you look at the top there, 1, 2, 3, and 4, those are what we call admonishments. They're really just explanations to you. Do you understand those 4 admonishments?
I do.
Going to the next paragraph, you'll see the next paragraph tells the court you fully understand, have read those admonishments, as well as the allegations in these, excuse me, enumerated paragraphs, which allege violations of your deferred adjudicated probation. Do you understand that?
Yes, sir.
This, and then you say, understanding the admonishments and the allegations, you say you make the following free, knowing, intelligent, and voluntary stipulations of evidence. Obviously, you're the individual I placed on deferred adjudicated probation in this case. Then under 2, you say that the allegations as set out in paragraphs 3, 5, and 6 of the state's motion to adjudicate your guilt are true, and that you are stipulating and entering pleas of true to the allegations in the state's motion to adjudicate, which allege violations of your deferred adjudicated probation in paragraphs 3, 5, and 6. Is that correct?
That is correct.
Are you stipulating and entering those pleas of true to those enumerated paragraphs freely, intelligently, knowingly, and voluntarily?
I am.
And you did go over this document, which is going to be marked as States 5, the written plea admonishments stipulations of evidence, with your attorney, Mr. Fletcher, prior to the time you signed, and you've now sworn to it. Is that correct?
That is correct.
All right, the court does approve States 5, the written plea admonishments stipulations of evidence signed and now sworn to by the defendant, signed by his attorney. You want to offer in States 5, Mr. Gilmore?
Yes, Judge, we will offer States 5, and the state will be abandoning paragraphs 2 and 4. I do believe that paragraphs 2 and 4 were accidental repetitions of paragraphs 3 and 5.
Just for the record, the state's motion to abandon the allegations in paragraph 2 and to abandon the allegations in paragraph 4, those motions by the state to abandon paragraphs 2 and 4 are granted.
And Judge, we have no objection to the entry of that.
All right, State's Exhibit 5, which is the written plea admonishments stipulations of evidence signed and sworn to by the defendant, signed by his attorney, containing the defendant's stipulated entered pleas of true to the enumerated paragraphs 3, 5, and 6 of the state's motion to adjudicate. States 5, the written plea admonishments stipulation of evidence signed and sworn to by the defendant, signed by his attorney, or admitted, states five, admitted into evidence, written plea admonishments, stipulations of evidence with no objection. The court having admitted into evidence stage five, the written plea admonishments and stipulations of evidence containing the defendant stipulating entered pleas are true to the allegations alleging violations of his deferred adjudicating probation in paragraphs 3, 5, and 6. The court does find the allegations in paragraphs 3, 5, and 6 of the state's motion to adjudicate guilt to be true based on the defendant's stipulated and entered pleas of truth. The court then does grant the state's motion to adjudicate guilt. The court does find the defendant guilty of the offense of possession of a controlled substance, state jail felony as alleged in the indictment. You have a recommendation, Mr. Gilmore.
Your Honor, we have an agreed recommendation of 9 months state jail time, Your Honor.
Mr. Fletcher.
Yes, sir, that is the agreement.
The court following the agreement in this case, having granted the state's motion to adjudicate, the court finds the defendant guilty of the offense of possession of a controlled substance as alleged in the indictment in cause number 2410624-16. Court follows the agreement between the state and defense and the defendant, and the court assesses the sentence having adjudicated the defendant's guilt and finding him guilty of the offense charged in the indictment. The court assesses the sentence at 9 months in a state jail facility. That's assessed with credit for time served, restitution ordered to DPS for the lab fee analysis. Any legal reason or formal sentencing, Mr. Fletcher?
No, Your Honor.
Finding none, the court formally pronounces sentence. The court does grant the state's motion to adjudicate. The court does find the defendant guilty of the offense alleged in the indictment, possession of a controlled substance, state jail felony. Court assesses the sentence at 9 months in a state jail facility. 9 month sentence to be assessed for credit for time served, restitution ordered, Department of Public Safety, lab fee for the analysis of the controlled substance. Sentence is formally pronounced. I have a waiver of appeal, Mr. Morris, going up on the screen. It's signed by, well, actually, just for the record, this is signed by Attorney Zach Davis. So apparently one time he was appointed to represent you. So let me be sure, Mr. Fletcher, obviously, do you approve and present to the court the waiver of motion for new trial, waiver of motion in arrest of judgment, and waiver of right to appeal, Mr. Fletcher?
Judge, I believe that was previously signed under the plea bargain, so yes, we'll present that to the court.
All right, court receives and accepts the waiver of appeal, waiver of motion for new trial, waiver in arrest of motion in arrest of judgment, approves the document, orders to file the papers of the cause. It'll be the order of the court now. Mr. Morris, you are continued in the custody of the sheriff until you can be transported to a state jail facility to serve the 9 month sentence assessed by the court with credit for time served, restitution order, Department of Public Safety lab for the analysis of the controlled substance. Sentence is formally pronounced. Anything else, Mr. Fletcher?
No, Your Honor.
Anything else, Mr. Gilmore?
No, Your Honor.
All right, defendant's continued in custody until he can be transported to a state jail facility to serve the 9 month sentence assessed by the court. Following the agreement of the state defense, 9 month sentence assessed with credit for time served, waiver of appeal accepted. Defendant's continued in custody until he can be transferred. If there's nothing else, Mr. Fletcher, do you have anything else?
No, Your Honor.
Anything else, Mr. Gilmore?
No, Your Honor.
We're in recess.
Thank you, Judge.